अपना नाम लिए बगैर अपना एक संपूर्ण परिचय हमें दीजिएगा आप।
Sir, I belong to Uttar Pradesh, Timeline Farkhabad, and I have completed my graduation and schooling from my hometown. And I have completed my LLB from Los Angeles, Delhi University. And then I have completed my LLM in corporate law in Rama University, Kanishk. Then I posted as a civil judge junior division in GMFC in Jharkhand, Gadwa.
वेरी गुड। आप जैसे बता चुके हैं कि ऑलरेडी आप सिविल जज हैं झारखंड में, तो फिर आप
Yes,
यहाँ
yes.
पर उत्तर प्रदेश में क्यों आना चाहते हैं?
Sir, actually, UP is my home state. And I have given the exam in 2018, but unfortunately I have not cleared it. But after this, I put a more effort. And sir, as a pendency wise, there is a lot of pendency in UP, so it gives me the lot of opportunity and to perform the multidimensional work in UP.
आज का अखबार आपने पढ़ा होगा, तो झारखंड के चीफ
Yes, sir.
मिनिस्टर ने एक कैबिनेट ने वहाँ के एक इस तरह की पॉलिसी निकालने का विचार कर रहे हैं कि बाहर के छात्रों और छात्राओं को वो सरकारी जॉब में अब
Yes, sir.
कोटा नहीं देंगे। आपकी क्या राय है
Yes,
इसमें?
sir. Sir, actually, sir, the right to choose a profession is a fundamental right, I think. Every person can do it, but as per the state policy, and we see that from the other state also, like Haryana, MP, and Rajasthan, they also implemented on the same guideline that they preference on their own students from state. And sir, sir, I think it is a kind of biasness, but as per the population criteria, some state has adopted to
वेरी गुड।
inculcate the problem of unemployment.
अच्छा, अगर ये यूपी में कर दिया जाए तो आप इसके फेवर में हैं?
Yes, sir. I think no, sir. Because this is against the meritorious, because it forced to choose a student and to candidate which is not meritorious as compared to the other who belong to the other state.
ओके। अच्छा, डीपीएस पे आपने नाम सुना होगा, उसमें सबसे
Yes, sir.
आपको ये कैसे आर्टिकल का नाम बताइए, जिससे आप सबसे ज़्यादा आपको सबसे अच्छा लगता हो?
As far as right now, I think the major demand is the environment. So to protect the environment and forest and the wildlife, and
इन
so
विच
that the
आर्टिकल?
all human beings are safe. Article 51 A, capital A, clause I am not remember exactly,
बट
but
आई
I
सेड
think
फंडामेंटल, आई सेड डीपीएसपी, नॉट
oh
फंडामेंटल।
DPS. I'm so sorry, sir. Sir, DPSP Article 48 capital A.
ओके।
And sir, recently I want to add something. There is a lot of debate under Article 44 Uniform Civil Code right now. I think
ओके।
this is a debatable issue.
ओके। अच्छा, एक आर्टिकल है 142, इससे रिलेटेड
Yes,
कोई
sir.
केस लो बताएंगे आप?
Sir, Article 142, there is a leading case law. I think the Supreme Court has a power in order to justice to pass any decree or order. Like in Ashok Vardha versus Rupa Ashok Vardha, I think the Supreme Court can give a judgment, leading judgment, I think, on this.
ओके। भारत में भी एक नई पार्लियामेंट बिल्डिंग बनी है।
Yes, sir.
आप मुझे बता पाएंगे उसमें टोटल कितनी सीट्स रखी गई हैं?
Sir, as for the Lok Sabha 550, because two seats for Anglo-Indian, I'm so sorry, sir, I don't know exactly.
अच्छा, झारखंड की पहली महिला गवर्नर का नाम मुझे बताइए।
Srimati Draupadi Murmu.
ओके। वुमेन कमीशन भारत में उसकी क्या स्ट्रक्चर है?
Sir, Women Commission, there is a chairman of Women Commission is Ma'am Shri Rekha Sharma ji. And sir, Women Commission was established to form basically the all the
आई आस्क्ड
uh,
ओनली स्ट्रक्चर, मेंबर्स एंड प्रेसिडेंट ओनली, हाउ मेनी
sir,
मेंबर्स?
I don't know.
ओके, मैं आपको एक प्रॉब्लम दे रहा हूँ, आप पहले इसको ध्यान से
Yes, sir.
सुनिए फिर आंसर करना। मान
Yes,
लीजिएगा
sir.
आप एक ट्रेन में सफ़र कर रहे हैं और
Yes, sir.
आपने एक सिगरेट पीनी है, और
Yes, sir.
सिगरेट
Yes,
पीने
sir.
के लिए आपके पास में एक इंसान, कोई एक व्यक्ति है, वो सो रहे हैं। आपने उनकी जेब
Yes,
में
sir. Yes, sir.
जो है लाइटर को चुराकर सिगरेट
Yes, sir.
जलाकर आप पी रहे हैं, और
Yes, sir.
आपको टीटी पकड़ लेता है। आप
Yes,
बताइए
sir.
आपने
Yes, sir.
कौन-सा ऑफ़ेंस वहाँ पर किया है?
Sir, as per Section 95 of the Indian Penal Code 1860, it is falls under the category of trifling offences. The offences is such of a petty nature, which is as an ordinary human being will not file a complaint in this. Uh, Sir, I think no offence if it is fall under Section 95 of the Indian Penal
ओके। तो आपका पूरी तरीके से ये कहना है कि ट्रेन में हम सिगरेट पी सकते हैं पूरी तरीके से?
No, sir. But as the case of Murli as Dev Gowda, no one can cigarette नहीं पीना है. To मतलब this is the leading case I think in this point. Murli as Dev Gowda.
प्लीज़ कंटिन्यू ममित सर, प्लीज़।
जैसा आपने बताया कि आप झारखंड में जुडिशियल मजिस्ट्रेट हैं इस समय।
जी सर, जी सर।
जी, तो ये बताइए कि आपके सामने मामले आते होंगे सेक्शन 156 क्लॉज 3 सीआरपीसी में। तो वहाँ
जी सर।
पर जो जुडिशियल मजिस्ट्रेट हैं वो इन्वेस्टिगेशन का ऑर्डर देते हैं। तो आप
जी सर।
यहाँ पर जो इन्वेस्टिगेशन की ऑर्डर की हमने पावर दी है मजिस्ट्रेट को, इससे आप सेक्शन 202 क्लॉज 1 में जो मजिस्ट्रेट
जी सर।
इन्वेस्टिगेशन का ऑर्डर देते हैं उनके बीच में आप कैसे डिफरेंस देखते हैं?
Sir, there are two things. If the person who wants to file a police case, then he approach to the court and go to the police station under section 154 CRPC. But as far as the sir 156 clause 3 is concerned, the person has filed an application under section 156 clause 3. Then, as per the case of the Priyanka Kumari versus State of UP, as per the magistrate has to see that whether there is a cognizable offence has been committed, whether there is a prima facie case has been made out, and whether uh, the compliance of Section 154 Clause 1 and Section 154 Clause 3 has been complied with or not. After taking these three steps, if the magistrate finds that there is a prima facie case made out, and then we have to see that the application under Section 156.3 to the concerned PS.
And what about
Sir,
section 202 clause 1?
sir, as far as the Section 200 Clause 1 is talking about the examination of the complainant and the witnesses present to panel. If the persons who, sir, I personally, if a person can file an application as a complaint, then I took a view and asked to the complainant that whether he wants to send the complaint under section 156 clause 3 or not. So, sir, they have the choice. If they on the spot says that, sir, please take a date on section 200 CRPC, then I commit a date for 200 for the examination of the complaint as a complaint proceeding case. And sir, if they want that they want to send his application under section 156 plus 3 CRPC, then I send after compliance with section 154 clause and 154 clause 3. Sir, it is basically as the choice of the complainant, whether he wants to pursue his case in the court or he wants to send it under section 156 clause 3.
ओके ओके ओके। अच्छा ये बताइए, यदि आप एक कंप्लेंट केस में आपके पास मामला आता है, आप कॉग्निजेंस ले रहे हैं और फिर आप इंक्वायरी या ट्रायल कर रहे हैं उस मामले में, और आप ये पाते हैं कि उस मामले में एफआईआर पुलिस ऑफिसर इन्वेस्टिगेशन कर रहे हैं, तो ऐसे में आप क्या करेंगे आप? क्योंकि एक तरफ तो कंप्लेंट केस लॉज हो चुका है और आप उसमें इंक्वायरी या ट्रायल कर रहे हैं, इस स्टेज पे आपको ये पता चल रहा है कि पुलिस ऑलरेडी इन्वेस्टिगेशन कर रही है। जी
सर, as per section 210 of the Criminal Procedure Code 1973, which deal with this problem, that the complaint is running on and it is informed to the court that the investigation, police investigation is also carrying on. So I stop the complaint case and call for the police investigation report. And after submitting the charge sheet, I see both the cases, the complaint case and police report case. If any of the accused is matched, the subject matter is matched, and then I take a whole case as a police case and merge with, tag with the complaint case in the police report case.
Okay. And what is curative petition?
The curative petition, the concept is the deal under Rupa Ashok Hurra versus Ashok Hurra, in which if the review petition is dismissed, then the last recourse to the petitioner to file a curative petition.
Okay. And what is the difference between prohibition and statutory writs?
Sir, the prohibition and statutory, these are called the sisters writ, because one of the writ, after taking the decisions by the court to quash the decisions, it is passed by the higher court to the lower court. But before pronouncing it, if the higher court prohibit to the lower court not to do this, not to exceed the jurisdiction which is not restrained by the law, then the writ of prohibition is issued. Basically, it is dealt with the jurisdictional matter. It is issued by the higher court to the lower court.
Okay. One last question to you. Can you
Yes, sir.
define the contract of guarantee?
Sir, contract of guarantee is a special contract. I'm not remembering the section number, but sir, contract of guarantee in which suppose there is a creditor the debtor wants to take a loan to the creditor. Then he said that he to give me the guarantee, then I have to do something. So it's a guarantee in which there is a three contract. One is the original promisor and promising, and the other one is the debtor and the guarantor, and third one is the guarantor and the creditor.
Okay. Okay, Kanishk, thank you so much. I would like to request Mr. Ravi sir, kindly continue.
Yes, sir.
Good evening, Kanishk.
Good evening, sir.
Kanishk, I'm audible to you.
Yes, sir. Audible.
Okay. Kanishk, in law college, generally we have here the three words that is called investigation, inquiry, and the trial. We all are
Yes, sir.
aware ki what happens in investigation. We all are aware ki what generally happens in the trial. But actually, what
Yes, sir.
happens in inquiry? Because normally the inquiry is conducted by the judicial magistrates.
Yes,
So,
sir.
being as a judicial magistrate, normally what is the exact procedure to conduct the inquiry?
Sir, there are three stages. First one is investigation, second is inquiry, and third is trial. And there is a difference between the inquiry and trial because where the inquiry stops, trial begins. There is a famous line. As per section 2G, inquiry other than trial conducted by the magistrate or the court. Sir, as far as we see the inquiry in a specific term, we see that trial is of a case which results into the acquittal or conviction. But as far as the inquiry is concerned, it is for the case, it is for the any applications because the executive magistrate has to conduct an inquiry under section 145, 140, 147 of the CRPC. And as far as the inquiry is concerned, section 209 is comes as inquiry, 207 is an aspect of inquiry, 208 is an aspect of inquiry. And sir, very specially section 159 of the CRPC, in which the occurrence report was submitted by the investigating officer to the magistrate whether he will conduct the investigation or not, then the magistrate himself is conducting the inquiry in order to find out whether the order of investigation was passed or not. And secondly, in complaint proceeding, we have to see the section 202, in which the magistrate finds that whether or not there is a sufficient grounds for proceeding of the case, then the magistrate either conduct an inquiry himself in order to find out whether there is a sufficient ground for proceeding to pass an order under Section 204 CRPC or not, or to pass an order under Section 203.
Okay. Kanishk, in CRPC, if we see the section of 438, which talks about the anticipatory bail, then we
Yes,
go
sir.
with the section 439, it talks about the regular bail. So there is a
Yes,
word
sir.
of or between the High Court and the word of the Court of Session. So I just
Yes, sir.
wanted to know ki what is the exact interpretation of the word of or that is called athwa.
Sir, or and. And means there is a both, or means there is either one or either two. So if the one person wants to get an anticipatory bail, he has the get an anticipatory bail either from the session court. Generally, the accused take it, and I see that, and as the ABP number and anticipatory bail petition number, and the accused has the right to go to the high court concerned to get the anticipatory bail. It is the sole discretion of the accused person to get a bail. I think yes, sir. Yes, it's the interpretation of all.
Okay, so let's suppose, Kanish, if a person who has a reasonable apprehension that person is might be arrested, and that
Yes,
person
sir.
is, very much fear, and he's a very, threatening from the some local police authorities, and
Yes,
he's
sir.
believe himself ki if he go to the court of session, so 100% he
Yes,
would
sir.
be arrested. So can a person is having a right to direct to approach to the Honorable High Court?
Yes, sir. He has the right, but as a matter of judicial scrutiny and the propriety, he has to first move an application to the session court, learn it ADJ, sir, and then he, if the bail is rejected anticipatory, he can move to the high court. But he has the right to approach either the high court or either the session court.
Okay. And Kanishk, when any court is granting a bail to a particular person, So normally they are demanding some kind of security, some kind of sureties. So
Yes,
being
sir.
as you are already a judicial magistrate, so what kind
Yes,
of
sir.
circumstances, what kind of factors are you looking for before granting a bail to a particular person? Because sometimes it
Sir,
is very difficult to identify whether the person is really indigent or not.
sir, as far as the bail is concerned, it is a sole discretion of the magistrate, which has to be exercised on the sound judicial principle. It has to be depend upon the fact-to-fact case, and also as the section alleged. And also we have to see that when the case is instituted or lost, the FIR, we have to read the FIR, and also if the investigation is going on, we have to call for LCR, call for report from the concerned police station, case diaries, and also we have to see that whether the accused is a man of what is the influence on the society, what is the age of an accused person. If the accused is more aged about, then we generally granted the bail to the person. And I think it is a landmark case as a Satyendra until versus Union of India, in which the Supreme Court has gave a detailed guidelines on this regard. But as far as your question is concerned, whether the person is an indigent person, so the giving under Section 436 in the case of bailable offence, if the bail is granted and he has not filed a surety within 7 days, then the presumption is raised whether he is a indigent or not. And secondly, sir, if the person in the under the lot of custody and the person is in jail lockup for 2 or 3 months, 6 months, then the periodical review has to be taken by the DALSA, District Legal Service Authority, in which they find out, and especially the NGO persons who are touch in jail, whether the person who is in a position to take a lawyer or not. And they gave a representation to the court normally. And if they give the representation, then I appointed a lawyer as a as under the purview of DALSA, and then he represented and move an application to the bill. Generally, we see that they are in a difficulty to find out to get a surety. So we reduce the surety amount, like one surety, but in other accused person, we can get a two surety, and to also reduce the amount of the surety also. And and at the last resort, I think we can release it on the personal bond. This is the last resort. But I think if it is a more heinous crime, like it is required with custodial trial, then even though he is indigent person, we cannot release it of that accused person on the basis of that he is indigent person. So I think it's totally based upon the fact and circumstances at what offense he has committed.
Okay, Kanishk, one last question to you.
Yes,
Ki
sir.
till date, neither the Honorable Supreme Court of India nor the Honorable Parliament of India has
Yes,
declared ki
sir.
what comes within the purview of the rarest of the rare. So normally,
Yes, sir.
when you are trying to convict any person in a capital sentence or a death sentence, so
Yes, sir.
basically, what you are looking exactly for to give the capital sentence, because it is very difficult the interpretation of the word of rarest of rare.
Sir, as for the rarest of the rare, it is hardly to define what is rarest of the rare. I think I again say that it is depend upon the nature how he has committed the offense. Because let us take an example. Suppose there is the offense of murder. No doubt, actually the actus reus is the causation of death, but how to cause the death? Because if someone person has brutally caused his death, like brutally committed the rape, brutally committed the act of assault, then it is may fall under the category of rarest of the rare. So we have to see that at how the accused has committed the offense. It is the most prominent factor because no doubt the offense is the same, but it may be vary from person to person, and also especially what is the how he has previously convicted or not. If suppose a person who is previously convicted for an offense of murder for 3 and 4 an offense, and he has again brutally has committed the offense in such a manner that the society is horrified for this incident. I think this case may fall under the rarest of the rare case. So I think it's a subjective satisfaction. I think there is no clear-cut answer what exactly falls under the rarest of the rare case.
Okay, Kanishka, thank you so much.
Thank you,
It's
sir.
really nice talking to you, and I would like to
Thank you,
request
sir.
Honorable Akhilesh Tripathi sir. He will continue with you. Thank you so much, Kanish.
Thank you, sir.
Hello, Kanishk.
Hello, sir.
Few days ago, there was a news on media regards to Jharkhand High Court. Can you tell
Yes,
us
sir.
that what was that news?
Sorry, sir, there is a lot of news regarding that.
It was regards the internal security of India.
Um, Sorry, sir.
Okay, what is the building name of Jharkhand High Court?
Sir, the new building of Jharkhand was established in Dhurba, Ranchi, and which was recently organized 2 months ago. I do not know the name exactly.
There is how many district in Jharkhand?
24.
24. What is the motto line of Jharkhand government?
Sorry, sir.
Okay, what are the major challenge toward the Jharkhand judiciary?
Sir, as such, as for the whole judicial infrastructure, there is a lot of the persons who are concerning or connected with the magistrate when he was sitting on the dais. But as far as the Jharkhand judiciary is concerned, there is a little bit staff to associated with the magistrate, and so it is too little bit difficulty to work there. But as such, there is no problems in Jharkhand. But especially, I think the little number of cases as compared to UP, I think this is the first thing I think. Lodging the reduced number of cases. Pendency is much less.
Okay, give me the three solutions from the judiciary to control the
Yes, sir.
Naxalism in Jharkhand.
Sir, as for the Naxalism, the I think the police having more control over the areas in which the Naxalite usually escaped, especially from the jungle.
So
And
how can
sir,
judiciary
I think,
control the police directly?
sir, the police, I think, sir, as for the, sir, sir, if the Naxalite, I'm sorry, sir.
Okay. What has been decided in the case of Navtej Singh?
Navjit Singh.
Yeah.
Sir, as per Section 377, Navjit Singh Johar case is the landmark case in which the persons who are the gay, sexual, bisexual, or if he has privately has completed sexual intercourse or anal intercourse, so they are not punishable. But earlier they are punishable because it is a sexual identity. Sexualism is a part of Article 14, 19, along with Article 21, right to privacy and
Okay,
the
all
right to
right.
freedom of speech and
Okay, okay.
expression.
All right. What is 24 Pargana?
Sorry, sir.
Okay, there is a three ambition behind every job: name, fame, and power. To whom would you like prefer first?
Name, fame, and power.
Yeah, between these
Sir,
three, to whom you like
yes,
the
sir.
first?
Sir, I prefer the name and power and then fame.
Okay, thank you. Now I would like to request Sateen sir, please continue. Thank you very
Okay,
much.
sir. Thank you, sir.
कनिष्क जी आपका मुख कंप्लीट होता है। कनिष्क जी हम लोगों ने आपके
Thank you.
बारे में चर्चा करी है अभी, एक आम सहमति बना ली है। कुछ मैं बिंदुओं पर आपको बता दूं, हालांकि आप इन सब
Yes,
फेजेस
sir.
से निकल चुके हैं, परंतु एज ए क्योंकि अब आप इंटरव्यू देंगे यूपी में,
Yes, sir.
एक
Yes, sir. Yes, sir.
रिव्यू देना चाहते हैं आपको, ठीक है।
हाँ जी, हाँ जी.
हाँ, 2-3 बार आपका आई कांटेक्ट जो है वो डिसबैलेंस हुआ है, तो प्लीज़ थोड़ा उस पे
Okay.
और आप वर्क कर लीजिएगा अपने। 2-3 जगह हम लोगों ने नोटिस किया कि आप कुछ ज़्यादा डीप आंसर कर रहे हैं, मतलब जो चीज़ पूछी नहीं गई
Oh,
आप उसे बताने की कोशिश कर रहे हैं। उत्तर प्रदेश लोक
oh,
सेवा आयोग के कॉन्टेस्ट में थोड़ा गलत हो सकता है, क्योंकि यहाँ पर आप
ठीक
जो
है.
है मेंस में भी अगर हम ज़्यादा लिखते हैं तो पेनल्टी डाल देते हैं, तो इसलिए आप बस जितना
जी,
पूछें
जी, जी.
उतना आंसर करने की कोशिश करें, ठीक है। क्योंकि डेफिनेटली
ठीक है.
आप वहाँ तो रिवील करेंगे ही कि मैं क्या हूँ, तो
बिल्कुल.
एक्सपेक्टेशन ज़्यादा रहेंगी, लेकिन उस एक्सपेक्टेशन में आप मतलब ज़्यादा नहीं फ्लो में बह ना जाएँ, तो वो उसका भी ध्यान रखना है आपको, ठीक है, क्योंकि वो
ओके.
गड़बड़ हो सकते हैं। एंड ओवरऑल
समझ गया, समझ गया.
हाँ, लॉ में कोई दिक्कत है नहीं। थोड़ा-सा फैक्चुअल डेटा आप बेसिक वाला, जो बेसिक है उत्तर प्रदेश के बारे में, थोड़ा-सा अपने डिस्ट्रिक्ट के बारे में। हालाँकि मैंने एकेडमिक क्वालिफ़िकेशन अभी आपकी देखी है, एक कंट्राडिक्शन क्वेश्चन और बन सकता है आपने, क्योंकि आपने इसमें बीटेक मेंशन करा है अपने एकेडमिक,
Yeah.
कि आप इंजीनियरिंग करके आप जुडिशियल में आए हैं और फिर ये चूज़ किया, इसको लेकर आप आंसर एक बना लीजिएगा अपना। थैंक यू सो मच टारगेट फॉर आई से
Okay.
जुड़ने के लिए। उम्मीद करते हैं कि
Thank you so much.
डेफिनेटली आपका रोल नंबर पीडीएफ में
ऑल द
होगा।
वेरी बेस्ट।
ठीक है जी, ओके।
Thank you, sir. Thank you.